Okay. So after the technical difficulties have been resolved and we've switched over to another platform, we've covered so far the effect of the new system on European patent prosecution. We've talked a little bit about the new court system that will be in place to go along with this new type of patent, and to cover all the patents unless you opt out. And now we come to the most important part of the presentation, which is, at least from a university perspective and from a licensing perspective, is how does this new system affect license and other collaborative agreements? And I'll turn it over to Mariella, who will go through this final part.
Thank you, Bob. So the third part focus on the effect on licensing agreement. Let me briefly introduce myself. My name is Mariella Massaro. I have a law degree from the University of Turin, Italy. I practiced 15 years as an IP attorney at law in Italy, handling both litigation and transactional matters. I moved to Berggren with headquarters in Helsinki, Finland 3 years ago. I'm a partner there, and I recently qualified as a certified licensing professional because of many years of practice in the licensing sector. So Bob already mentioned some criteria that you may take into account when assessing the opportunity of opting out. Here's another thought. If the patent is licensed, you may have another incentive for opting it out because you want the patent to be safe and be able to collect royalties. And so it may be more convenient for a licensor to opt the patent out and avoid the risk of a central revocation attack. There is a mechanism in particular to which I want to draw your attention to. If an action is brought in front of the UPC or a national court in a matter over which the UPC has jurisdiction, this action has the effect of pinning the patent in the system in which it was at the moment in which the action was brought. So, for example, if the patent proprietor, licensee, or another party brings an action in front of the UPC and the patent was not opted out, then the patent proprietor is prevented from opting out for the entire life of the patent. So irrespective of the outcome of the action or the duration of it, the patent is pinned in that system. And likewise, if the patent proprietor, a licensee, or another party brings an action in front of a national court in a matter for which the UPC has jurisdiction and the patent was opted out at the time, the patent proprietor cannot opt back in. This is at least the default position. So under which conditions a licensee can bring an action, because we saw that the licensee can bring an action. Well, under the new system, an exclusive licensee is allowed to autonomously bring an action before the Unified Patent Court, provided that the patent proprietor is given prior notice. Thus, the patent proprietor prior consent is not needed. At least this is the default position. We can do something about that in our license agreement, of course. On the contrary, a non-exclusive licensee is not permitted to bring an action autonomously in front of the Unified Patent Court unless the license agreement expressly allows it to do so. From what I already said, it's apparent that the interests of the licensees and the licensor are not as aligned as they are in the current system, because the licensor, it is usually the patent proprietor, is more interested in the safety of the patent, so it may be more concerned about the risk of a central revocation attack, while the licensee may be generally interested in the efficiency and conveniency of a central infringement action. So as an owner, it's important that you review your current and future license agreement in order to take care of your interests that are now not as aligned with the interests of the licensees. So let's start with, no, sorry. Here it is. Yes, let's start with co-ownership agreements. It's important to remember that if there is an interest to opt out, and you are a co-owner of a European patent or patent application or SPC, that you have to remember that all co-owners must opt out. So now that we are still in the preparatory phase, it may be an opportune time for you to reach out to other co-owners, explain your interest in opting out, and obtain their consent. Also, if you are a co-owner of a patent application, you may want to discuss with the other co-owners who has which type of patent will be requested at the end of the European procedure. Will be a classic European patent that will be validated, or will it be a patent with a unitary effect? Also, with respect to future collaborations, so future joint co-ownership agreement, you needed to address in the co-ownership agreement these questions. So hopefully try to be the party who decides the type of the future patent that will be requested, the party who decides on opting out or opting back in if there is an infringement and you are interested in opting back in, or hopefully you are the party that will be responsible for implementing the decisions and bear the associated costs, or you can ask the licensee in the event it will be a licensed patent. So we know all the co-ownership agreements are kind of difficult, or like you may have, if it's another institution, a interinstitutional agreement. So the co-ownership is always a difficult topic. So it's very important that you address these issues so that there are no ambiguities and you will not end up in a conflicting situation later. Also, these questions are important to address in a license agreement, because of course a licensee does not enjoy the same rights as a co-owner. So it's the owner who decides the type of patent that will be requested, and in principle is the owner who decides to opt out. But if, as sometimes happens with non-European entities, which have a exclusive or say an important licensee in Europe, sometimes the licensee is given ample freedom during patent prosecution, because maybe the licensee is paying for the patent prosecution and is in charge of making certain decisions. So if the license agreement doesn't clearly state that you are the one who, as an owner, decides on certain issues, the licensee may argue that these are issues that relate to prosecution, and then so the licensee has also the right to express his preference. So avoid ambiguity and clearly state in the license agreement that you are the one who decides. Also, with respect to litigation, we saw that an action brought by a licensee can pin your patent in the system in which it was at the moment the action was initiated. So it's very important that your prior consent is obtained in order for the licensee to be able to start this action. And so this is important to clarify in the license agreement, because we saw the default position is that just the prior notice is required, not the prior consent. And therefore, either you request your prior consent, or at least if you have an agreement where like you leave the licensee free to decide to bring an action, you can put together a provision where you buy at least time in order to be able to exercise your right to opt out before the licensee brings an action. So you are at least dictating where the action will be brought. A very sophisticated licensee may also be concerned about certain issues that the new system is bringing. Like we saw with respect to co-ownership, it may be not easy to obtain the consent of all owners in order to opt out, for instance. And so a licensee may that has expressed a preference and obtained maybe from you that, agreed with you that the patent may be opted out in the future, that licensee may request that you, in the license agreement, guarantee that you are the sole owner. Sorry, you are the sole owner. So, or you are able to obtain such consent. So, I will not be surprised looking at this new system with the eyes of the licensee that in the future there will be some discussions about these issues in the representation and warranty clauses. With respect to the territorial coverage, now we will have finally a unitary patent with unitary effect. So this means that this patent can be limited, transferred, revoked, or lapsed with respect to all participating member states. It has a unitary effect. But with respect to licensing, it will be still possible to license, let's say partially, with respect, to that territory, a unitary patent. So in the future, it will be still possible to have an exclusive licensee for Germany and another one for France. Of course, the higher the number of the licensee, the more difficult it is to coordinate the litigation strategy. And we see, like, if we have one title, like one patent, and it's knocked out in front of the Unified Patent Court, this, of course, endangers the rights of all licensees. So probably in the future, there will be less licensees for unitary patents, because it's very difficult to coordinate with all licensees the litigation strategy, especially. So there's also another aspect of the new system that it's worth mentioning. The unitary patents will be regulated by EU law. So the Unitary Patent Regulation, the Unified Patent Court Agreement, the European Patent Convention. So all European sources of law at the European level. But there will be still certain issues that pertain to the patent as an object of property that will be regulated, will be governed by a national law. For instance, the validity of the license, and which is this national law. There are certain criteria, and so if the applicant has its residence or principal place of business, or a place of business in a European member state that is participating to the system, that law will be applied. But if there is a non-European applicant and is a sole applicant, so there are no other co-owners that have residence in or principal or a place of business in Europe, then German law will be applied because it's the law of the country where the EPO is located. In case of joint applicants, the criteria that is followed is the order of entry in the patent register. So pay attention if you have joint applicants from European member states that participate to the system, to list them in the order that you prefer with respect to the applicable law. Let's get some examples so to make this issue very simple. If we have joint applicants from the US and France, like it's easy, French law will be applied. And we are speaking just to issues related to the patent as an object of property, not other issues. If we have joint applicants from the US, Finland, and France, and both the Finnish and French applicant has residence or principal place of business in their respective country, the order of entry in the patent register is the criteria that will be used, and so Finnish law wins. But it's not the only criteria, the order of entry. So also the place of business or is let's say that the residence or principal place of business is also an important criteria. So in the event in which we have joint applicants from the US, Finland, and France, but only the French applicant has residence or principal place of business in this country, then French law will apply. So in my last slide, I listed the factors that may have an impact on the value of the patent and so the value of the license. If you consider that the unitary patent may be less expensive, at least we saw that if you validate in a high number of countries, we can say that unitary patent is less expensive. If you also consider that the unitary patent covers a larger territory and allows to obtain injunctions, other permanent or provisional measures, along with appropriate damages with respect to all territories where the patent has effect, then we can say that the unitary patent may have a higher value in a license. So maybe it's possible to negotiate a higher royalty rate. Of course, all these advantages come with a risk of essential revocation attack. So this is a minus. This factor it's maybe, of course, be assessed on a case-by-case basis, because if, for instance, you have a patent that successfully survived a radial European opposition, or you're confident for the prior art that was cited that you really have a relatively strong patent, then this factor has less impact. Also, we saw that it's very important to reduce the risk of an inopportune litigation brought by a licensee by carefully drafting your license agreement. So also like a careful drafting of the licensing or even co-ownership agreement can be a factor that limits the risks and so the negative factor. So it will be interesting as licensing professional to see in the future if the royalty rates for unitary patent will be higher and the licenses have more value. I think we prepared some free resources for you to access. On our website, we have a UPC website webpage where we publish articles, and we have a UPC timeline and checklist. Also, we linked the official website of the EPO Unitary Patent page and the Unified Patent Court frequently asked questions. So we'll share these resources with you. Thank you.
Thank you, Mariella. Okay, so we do have a question from Jessica. So the question is, what is the general sense you get from universities in regards to bulk opt-outs? Is this a path you found many universities considering? It's interesting because I think that a lot of people are still trying to decide what their overall strategy will be. There has been, especially with our European clients, maybe bulk opt-outs make more sense. It may be that with respect to U.S. universities, they're going to take more of a quite possibly a more selective approach, and it kind of feeds into one of the questions we get most often is what can you do now? And so one of the things to do now is identify the important patents, the revenue generating patents, the licensed patents, and at least have a list of those ready so that if you want to opt them out, you can do so when the time comes in the sunrise period. So that's probably the direction that most universities will take. Mariella, do you have any, and Michael, do you have any other thoughts on that?
No, I think that it's true. Let's say that also it's really difficult to predict if all the applicants will be able to do these bulk opt-outs, because we are speaking about an enormous amount of patents, and it will be really difficult to be able to do all the opt-out during the sunrise period for everybody. So I think that maybe, as Bob suggested, that starting to identify the triage. So maybe I start with the really important patents and see what happens in the next months, in the following months. Maybe a good idea. What do you think, Michael? From a practical point of view, let's say.
Yeah, from a practical point of view, if you want to play it safe, opt out all of your patents. And this might also, depending on the size of it, it depends on many factors. So if you have a considerably big portfolio, I think opting out all of your patents might be the way to go, because by having a large number of patents, you can also achieve cost effectiveness with opt-out providers. So that's my comment in this regard.
Yeah, there's actually no official fee for opting out, but of course there will be service provider fees. One other aspect to this is it may, and Mariella pointed this out specifically, is identify not just the important patents, but the co-owned patents, because you're actually going to have to collaborate with another entity to decide what the strategy is going to be. So I would say the important co-owned patents are the ones that are really at the top level that you would want to think about. Another aspect of this is we've had several universities request our assistance on reviewing their standard templates for license agreements, as well as interinstitutional agreements, and in order to let's say take this new system into account. The license agreements that were executed, of course, were done by most universities do a fantastic job of this, but there was no way to consider this new system that was basically on the distant horizon. So some of these agreements, I would guess that almost every agreement could be modified at least a little bit to take this new system into account, and we've done this for a growing number of universities. Any other questions? I said earlier that we are available, just as a reminder, we're available to give this presentation again to different groups, including your U.S. law firms, or as I understand it, this the audience here is from a number of different places. I think that's correct, but we're available to do this for your specific institution and your maybe some of your main U.S. law firms if you want them to understand what some of these considerations are. So please let us know if you want us to schedule another event. We're doing these all the time to make sure people are prepared for when this goes into effect.
And is it okay if I share your contact information with everyone?
Absolutely, please
Yes,
do.
of course.
Okay, anything else?
Yeah, I was just going to say anyone can unmute right now if you want to ask questions.
Thanks for the praise, Jessica.
not seeing any in the chat or any hands raised.
Okay.
So
Well, yeah, thank you, Karen.
Yeah.
Go ahead.
Yeah, I was just going to say thank you all for joining today, and thanks to everyone on the listener side, and for staying with us through the technical difficulties. I appreciate it.
Carolyn, thank you for solving the technical difficulties.
Yeah.
And anyway, we'll be attending, if any of you are going to be attending maybe the East Regional meeting. I guess you guys are more central, but East Regional meeting, we're also going to be out at the West Regional meeting, also at LES, talking about this quite a bit. So please do not hesitate to reach out to us if you need any assistance at all. And anyway, we'll be glad to help.
Okay. See any more questions? I think we can wrap up. I appreciate you all hopping on.
Okay. Thank you, Carolyn.
Thanks.
Thank you very much.
All right.
Thank you.
All right. Bye-bye.
Bye.
Bye.